We're here today in State of Ohio versus Thomas C. Albano. Case number 25CR001414. Defendant is present in open court today with his counsel, Leslie Johns. Your Honor, we're here today on a 4-count information that was filed on October 6th of 2025.
Sorry.
Those 4 counts being 2 separate and distinct counts of pandering sexually oriented matter involving a minor or impaired person, a felony, both felonies of the 4th degree, and 2 separate and distinct counts of voyeurism, both felonies of the 5th degree, one with a forfeiture specification. Those counts would not merge. It's the State's understanding today that the defendant will waive his right to indictment, that he would plead guilty to all 4 counts within the information as well as the forfeiture specification. At that time, we would ask to defer sentencing to order a pre-sentence report, psychological evaluation, and victim impact statements. There's no sentencing agreement, and that's the State's understanding at this time.
Thank you. Ms. Johns, is that accurate?
Yes, Your Honor, that is accurate, and my client is prepared to proceed forward today. We have reviewed all of the documentation in advance.
Sorry?
All of the documents in advance of today.
Thank you. Mr. Albano, is that how you say it? Albano? Or
Albano, Your Honor.
Albano?
Albano, yes.
Albano.
Your Honor.
Were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
You know, you don't need to stand. I appreciate that, but and I don't interpret that as any disrespect, but it's a lot easier. It's going to take a while. It's a lot easier being seated, so thank you. So were you able to hear what they said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'm going to explain that in a minute in more detail what that means.
Yes, Your Honor.
And then you're going to plead guilty to the 4 charges in the information, which I will also review with you to make sure you understand those. If at any point when we're going over everything, well, before we get to that, after you waive the grand jury, you're then going to be entering a plea of guilty to those charges. We're then going to defer sentencing to a later day to get some evaluations complete, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
I'm 54, sir.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
I prescribe medication, Your Honor.
What's that?
Lexapro.
Hang on. All right, go ahead.
There's another anti-anxiety medication I take. I can't remember the name of it.
That's all right.
And then just one for digestive health. One for digestive health. It's just it's antacid.
Oh, okay. Do any of those medications that you've taken in the last couple of days affect your ability to understand or appreciate where you are or what's going on around you, or
No,
make it difficult to communicate, understand, anything like that?
No, Your Honor.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the 4 charges you're accused of committing?
Yes, Your Honor.
You had a chance to look that over at some point?
Yes, Your Honor.
Now, in that information, as I said, there's 4 charges. Counts 1 and 2 charge the same offense, only that occurred during different time periods. Count 1 is alleged to have occurred on or between December 8th, 2024 and December 18th, 2024. And count 2 is alleged to have occurred between December 1st, 2024 and April 1st of 2025. Both of the offenses alleged to have occurred in Lake County, Ohio. And what's alleged with both of these is that you did, with knowledge of the character of the material or performance involved, knowingly solicit, receive, purchase, exchange, possess, or control material that shows a minor or an impaired person. Which one are we dealing with here?
Minor.
A minor. That shows a minor participating or engaging in sexual activity, masturbation, or bestiality. This conduct for both counts constitutes the offense of pandering, sexually oriented manner involving a minor or impaired person, and is a felony. They each are felonies of the 4th degree. Do you understand what you're charged with in pleading guilty to in regards to counts 1 and 2?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
Now, counts 3 and 4 also allege the same offense, so again, but different dates. In count 3, it's alleged that it occurred on February 16th, 2025. Count 4 is alleged to have occurred on February 28th, 2025, and both offenses are alleged to have occurred in Mentor Lake County, Ohio. And on that date and that place, it's alleged that you knowingly trespassed or otherwise secretly or surreptitiously videotaped, filmed, photographed, broadcasted, streamed, or otherwise recorded a minor, to wit, a minor with the initials MS, in a place where a person has a reasonable expectation of privacy for the purpose of viewing the private areas of the minor. That conduct constitutes the offense of voyeurism.
Count 3 has additional victims, Your Honor.
Oh, thank you. No, all right, I missed that. These acts constitute the offense of voyeurism. They're each felonies of the 5th degree. Now, count 3, there is a total of 3 alleged victims, minors with the initials of JG, MS, and ES. Count 4, there's 1 victim with the initials MS. So do you understand what you're charged with in pleading guilty to in regards to counts 3 and 4?
Yes, Your Honor.
Any questions about either of those charges?
No, Your Honor.
Now, count 4 also carries with it what we call a forfeiture specification, which alleges during the commission of the offense you had in your possession or control an iPhone, a camera, and an SD card, which were used as instrumentalities. Instrumentalities are property that there may not be anything illegal about them in and of themselves, but they're being used in an illegal manner to facilitate a crime. You can't use or possess them for that purpose. And here it's alleged you had those items to commit the offense of voyeurism. Whole point of this specification is that you forfeit any ownership interest you have in that property. It doesn't increase any potential penalty you face, but you forfeit any ownership interest. You understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
So you understand the nature of the 4 charges you're pleading guilty to?
Yes, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So the charge I just read to you, we call it an information, and that's a criminal charge or charges brought by the prosecutor's office without the case having previously been considered or reviewed by a grand jury. A grand jury is made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Now, everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not, and you have that right as well. But you can't give up that right if you desire and go forward on the charges brought by the prosecutor and the information, and your attorney has indicated to the court she believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court, in writing, and I have in my possession here a one-page document called a waiver of indictment, which sets forth what I've just explained to you about this grand jury process, and that you want to give up that right. Before I can go any further, I need to be assured you understand the document and that you sign it here in court. Now, my understanding is that before I walked out here, you had a chance to go over that document. I think your lawyer alluded to it as well. Before I came out here, you had a chance to review that with her. Is that correct?
Yes, Your Honor.
Ms. Johns, is that accurate? Did you review this with your client, go over it with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Albano?
Yes, Your
So
Honor.
you understand what the document says?
Yes, Your Honor.
You have any questions for me about it?
No, Your Honor.
Now, it also appears you signed the document. Did you sign it?
Yes, Your Honor.
And you witnessed that, Ms. Johns?
I did witness it.
And Ms. Cuts, you too?
Yes, John.
All right, thank you. I will make that document part of the record in this case. At this point, Mr. Mr. Albano, I'm going to ask you, I'm going to review with you all the other rights you're giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And the jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means all 12 of the jurors would have to agree together one way or the other as to each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we did have a trial, prosecutor, well, first of all, you'd have a right to have a lawyer represent you at the trial. If you could not afford a lawyer to represent you at trial, the court would appoint one for you free of charge. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence remains with you and stays with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we call proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I just read to you beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would bring witnesses to come into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. And that's called cross-examination. She'd be permitted to ask them anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right.
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that is solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding I will enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about all these rights we've just discussed? These are all the rights you have and all the rights you're giving up. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue on a later day that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to 4 charges here. The first 2 counts, the pandering charges, are felonies of the 4th degree. Each of those carry with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, counts 3 and 4, the voyeurism charges, are felonies of the 5th degree. Each of these charges are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
Now, since there's 4 separate charges here, a prison term was imposed. A prison term would be imposed on each count. Then, as the judge, I have the discretion to run those prison terms either concurrent with each other or consecutive to each other. And when I say concurrent, that means together at the same time. So you'd serve those terms together at the same time. Consecutive is one after the other. You'd serve the prison term on the first count, finish it, then the next 4, and so forth for whatever sentences are consecutive. You understand the difference there?
Yes, sir.
So in this case, if I imposed a maximum sentence on each count and ran them all consecutive to each other, you're looking at a maximum possible prison term of 60 months, or the equivalent of 5 years. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole or supervision to any other courts or agencies?
No, Your Honor.
Do you have any other charges, criminal charges pending against you anywhere?
Yes, Your Honor.
Where's that?
In matter, Your Honor.
What kind of charge?
There were
Is it a felony or misdemeanor?
Misdemeanor.
Your Honor, they're misdemeanor offenses. He's awaiting sentencing. The court is aware of this case.
Okay.
And his
The reason I asked in particular if it's a felony, if you're sentenced to prison in another case prior to being sentenced here, I could run a prison term in this case concurrent or consecutive to that.
Yes, sir.
If it's a misdemeanor, you can't get a prison sentence, so that's inapplicable. So it would have to be a felony that you were sentenced to prison on before you came here. I can't run a sentence concurrent or consecutive to some possible future unknown sentence. It's got to be already imposed, so that doesn't seem like it's applicable here. Now, if a prison sentence is imposed in this case, upon your release from prison, you would be placed on what we call post-release control, and it would be for 5 years in this particular case. Post-release control is sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And again, in this case, it would be mandatory, and it'd be for 5 years. Do you understand that?
Yes, Your Honor.
And if you find yourself on post-release control at any point and ever violated any of the conditions of your supervision, a parole authority could return you to prison as punishment for violating the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that can be imposed. You could be fined in this case. The 2 pandering charges in counts 1 and 2 carry with it a possible fine of up to $5,000. The 2 voyeurism charges carry with it a possible fine of up to $2,500. So altogether, with all 4 counts, the maximum possible fine of $15,000. You can also be ordered to pay court costs and also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution if that's applicable to any victim for an economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes, Your Honor.
Also, in regards to that forfeiture specification that I read to you in count 4, dealing with the phone and the CD card or SD card, and I can't remember what the other item was, but any right, title, or interest you have in any of that property in the forfeiture specification at the time of sentencing will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
Also, inasmuch as the offenses you're pleading guilty to are sexually oriented offenses, at the time of sentencing, you will be classified as a Tier 2 sex offender. That will require you to register in person with the county sheriff in the county that you reside, as well as work and or go to school if any of that's applicable. You have to register your address with them when you first, after sentencing, and then every 180 days thereafter, you have to do that for 25 years. Do you understand that?
Yes, Your Honor.
All right, now a few moments ago I explained the possible prison sentence you face. I used the word possible. Prison's not mandatory or required with these charges. You are eligible for probation or what we call community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that if that's what you're requesting. I'm going to look at all the information that gets presented to the court. Then I'll make the decision that ultimately I think is the right and fair thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions at any point, it could be for up to 5 years. And as a judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. So even if you were to be placed on probation, it doesn't automatically mean no incarceration. It doesn't mean there is. But you could be incarcerated locally in the county jail for up to 6 months as a condition of your probation. You understand that?
Yes, Your Honor.
Further, if you're on probation at any point and you ever violate any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can order or impose more restrictive sanctions, including local jail time, or I could terminate or end your community control and send you to prison at that point. If I did it then, again, it could be up to a total of 60 months in prison. And that could also be consecutive to any other prison sentence you may be serving if there's a new case or that you're being sentenced to for a new case at that time. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor also has the right to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone has to say regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all for me regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyers, have them review the reports with you, discuss the issues, answer whatever questions you may have?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyers?
Yes, Your Honor.
Have they, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your guilty plea freely and voluntarily?
Yes, Your Honor.
All right, Dad, any questions for me at this point regarding anything we've just talked about, the rights you're giving up, penalties
No,
you
Your
face, what you're pleading guilty to?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would establish at a trial or demonstrate if we did have a trial. I want you to listen to her because I got some questions for you, all right?
Yes, Your Honor.
Ms. Cutts.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on April 1st of 2025, the Mentor Police Department, specifically Detective David Palcho, was assigned a cyber tip from the National Center for Missing and Exploited Children, indicating that Kik, a social media platform, is aware of 13 videos that had been shared with others between December 8th of 2024 and December 18th of 2024 that were of a concerning nature, possibly child sexual abuse material, child sexual exploitation material. The account for Kik had a username and email connected to it. It was a Gmail account. 11 of the videos were sent from a residential IP address that went back to Thomas Albano, the defendant of 5521 Dearborn Avenue in Mentor Lake County, Ohio. 2 were also from a mobile IP address. The 13 videos that were sent included 8 unique files, The majority of them included prepubescent females. One involved a toddler female that included various activities to include fellatio, masturbation, and attempted penetration. Investigation was done as to the Kik account. The email address was found to come back to an owner by the name of Tom, specifically the defendant. Within that Google account were selfies of the defendant as well as his wife and other individuals. A search warrant was done for the Kik account as well. There were, again, photos and videos of the defendant and others connected to his life within there, as well as the videos from the cyber tip, as well as additional videos that included pubescent females but still minors involved in masturbation that had not been included within the cyber tip. There were also chats of a sexual nature regarding daddy-daughter chat groups that involved conversations regarding the defendant's stepdaughter, who was 11 at the time, and biological daughter, who was 21 years old at the time. Those cyber tip images were all found to be sent to either additional Kik users or to groups within Kik itself, chat groups. JFS was contacted. Contact was made with the defendant's wife due to the knowledge that juveniles were living in the home with the defendant and his wife. Contact was made with the defendant. There's an agreement that he would leave the home during investigation. While officers were in the home, as the defendant was leaving, on the dresser in the primary bedroom or master bedroom was a small black Wi-Fi mini camera with an SD card. The defendant's wife requested to have the camera looked at and any video footage on that. In addition, previously, the defendant's iPhone had been taken in an unrelated case, so a search warrant was obtained for the cell phone. On the SD card in the camera, it was later found that the camera had been put in the upstairs bathroom of the home and recorded various individuals in different states of dress or nudity within the bathroom. And on the phone, there were additional video clips from that camera showing that the camera was hidden in the bathroom from different dates, from December 14th of 2024 to approximately February 28th of 2025. The clips that were most concerning to law enforcement were on February 16th of 2025, where there were images of body parts of a then 16-year-old male, full frontal, of the buttocks and bodies of then 11-year-old MS and 12-year-old ES. On February 28th of 2025, there were more videos that included additional images of MS, who was 11 at the time, in a state of nudity. None of these individuals were aware that there was a camera filming them at that time. All of these events occurred in Lake County, Ohio, and that would have been the state's evidence.
Thank you. Mr. Albano, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
I'm sorry, Your Honor.
Were you able to hear what she just said?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding counts 1 and 2, each charging you with the offense of pandering sexually oriented matter involving a minor or impaired person, a felony of the 4th degree, what is your plea to each of those 2 counts?
Guilty, Your Honor.
Regarding counts 3 and 4, each charging with voyeurism, each felony is of the 5th degree, what is your plea to that count?
Guilty, Your Honor.
And regarding the forfeiture specification in count 4, what is your plea to that?
Guilty, Your Honor.
I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth everything I've just gone over with you. Before I can accept your pleas, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this document as well with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Johns, is that accurate? Did you review this with Mr. Albano, read it to him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, sir?
Yes, Your Honor.
You understand what the document says?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
It also appears you signed this document. Did you sign it?
Yes, Your Honor.
And you witnessed that, Ms. Johns?
I did.
And you too, Ms. Cutts?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of counts 1 and 2, pandering, sexually oriented matter involving a minor or an impaired person, each felonies of the 4th degree, in violation of 2907.322A5, as well as counts 3 and 4, voyeurism, each felonies of the 4th degree, violation of 2907.08, as well as a forfeiture specification in it's .08c in the forfeiture specification in count 4.
Your Honor, the voyeurisms are felonies of the 5th degree.
What did I say?
I thought you said 4th.
All right, it's felonies of the 5th degree. If I said 4th, that was a mistake. So the voyeurism, you're being found guilty of voyeurism, felonies of the 5th degree, violation of 2907.08c. I'm going to defer sentencing and go in order of pre-sentence report, evaluation, victim impact statements, psychological evaluation. As to bond, I got some paperwork for an OR bond here. Has that been agreed to?
Your Honor, there's been no agreement to bond. We just wanted to give the court the opportunity. Since the defendant did show, we would defer to the court. We would ask for bond conditions. We would specifically ask for no unsupervised contact with minors, no contact with the victims in this case, that he follow the protection order that is currently in place, and that he not use the internet, or at a minimum, not use social media. Thank you.
Ms. Johns?
Thank you, Your Honor. The defense has no objections to the conditions as outlined by the state. We do believe that those would be appropriate. As the court is aware, we proceeded by information. Mr. Albano came voluntarily, is eager to resolve this matter, certainly would comply with any orders of the court and the orders pending sentencing. Your Honor, my client is gainfully employed, has limited criminal history other than that case in Menor that was just resolved last week. It did not involve the victim.
What were the charges in that case?
A plea was to a menacing and to a weapons while intoxicated misdemeanor. As the state alluded to in her recitation of facts, that incident occurred and then this investigation took place. He has been abiding by the orders of Menor Municipal Court pending the outcome of that case and has complied with all protection orders in place, and we believe that a OR bond in this case would be appropriate in light of what has been stated today.
Thank you. All right, the court will set bond on the defendant's own recognizance with the condition they have with the conditions that he have no unsupervised visit with minors, he have no contact at all with any of the victims in this case, that he comply with whatever outstanding protection orders are in place, and that he not go on or use any social media. I think that covers everything. Ms. Cutts, is there anything else?
No, thank you, Your Honor.
John?
No, thank you.
All right, thank you. Oh, I have an order here he needs to... So he hasn't been booked in or anything on this case yet. So, plus I want to explain some other stuff real quick. So in regards to the bond, Mr. Albano, I'm sorry, there's some more I have to say. I said an OR bond, owner cognizance. That means you have to show up at all future court dates.
Yes.
If you fail to appear at any future court date, that's a separate felony of the 4th degree that you can be prosecuted for. and receive an additional 6 to 18 months on whatever may happen here if they're sent to prison. So it's obviously important you show up at all future court dates.
Yes, sir.
I've set forth several conditions of your bond here. Another condition is that you don't use any drugs while you're on bond.
205 days clean today.
Well, you have to submit urine screens if requested. They must be negative. A positive screen will result in your bond being revoked and a warrant being issued. Do you understand that?
Yes, sir.
Now, the purpose of these reports that I've ordered is so I can learn more about you before sentencing. The way the probation department gets the information they need to prepare the report is they're going to conduct some interviews with you. So it's important that you show up when you're supposed to, first of all, and then when you meet with them and speak with them, that you're open and honest with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in some way, they're going to let me know that, and I would obviously consider that at sentencing. You understand that?
Yes, sir.
All right, so you're going to leave here now, and you're going to go over to the probation department. You also need to go to the jail and get booked in. We're going to give you an entry in order here, authorizing the jail to tell them that you need to be booked in and booked out. It takes a little bit of time. Once that is over, you're to go then to the probation department. So you first go into the jail, tell them you need to get booked in, and they'll bring you wherever they need to bring you to get that done. After that takes place, you're going to go up to the third floor of the jail. Not the jail side, but the other side, to the right when you walk in the front doors, to the probation department. And they'll be waiting for you, and you're going to fill out some initial paperwork and get your dates to come back for the interviews, all right?
Yes, sir.
So make sure you do all that. Stan, when is the sentencing date?
12/8 at 2:45, sir.
So your sentencing in this case is... Now, let's check on that. Come back around before you leave. All right?
Sure.
All right. How did we get that date?
That was Amy that gave it
Did she talk with anybody?
Yes.
That, usually we do give probation a little more time. We'll talk. We'll come back around. We're going to talk. All right. Anything else for the record, Ms. Cutts?
No, thank you, Your Honor.
Ms. Johns?
No,
All
thank
right,
you.
thanks.
All right.
Now we're hearing case 25 CR 1324, State of Ohio versus Aaron Seymour. We are here for arraignment. Defendant having been indicted by the grand jury in a 2-count indictment. Ms. Tomazik?
Yes, thank you, Your Honor. Mr. Seymour today would like to enter a not guilty plea. He is willing to waive the reading of the indictment in any manner or defects in service, Your Honor. And we would like to talk about the motion that was filed to revoke bond that was filed on 11/5. Thank you.
Mr. Seymour, did you receive a copy of the indictment?
Yes, Your Honor.
Did you have a chance to review it?
Yes, Your Honor.
You have a right to have me read you this indictment if you'd like, and I can do that. I'm happy to do that, or you can waive the reading of the indictment. What would you like to do at this time?
I can waive it.
Very well, then, as to the 2 counts of this indictment, what is your plea to each of those 2 counts?
Not guilty, Your Honor.
Thank you. The plea of not guilty will be entered. Give me 1 second, please. Ms. Gretzky, State's position on bond. I have your motion, obviously, and I've read that.
I have the judgment entry for the in-court arraignment. I don't know if that was emailed separately.
No, I need that.
I have a paper copy. May I approach?
Please. Thank you.
And in regards to bond, first by way of history in this case, these charges stem from a traffic stop by the Portland Police Department where drugs and drug paraphernalia was found in the defendant's vehicle. The defendant at that time was with a woman who turned out to be the victim in the case in Geauga County. The items that were found were sent to the crime lab, and accordingly, the charges were filed with what substances were found in the car, 2 counts, felonies of the 5th degree. In Willoughby Municipal Court, an explicit bond condition was made that went a bit beyond what we have standard, which is no alcohol substances within 24 hours of a hearing. In Willoughby Municipal Court, it was explicitly stated the defendant shall not consume alcohol or illegal drugs or substances. After this case was indicted, I found out about the case in Chardon Municipal Court, which occurred about a week prior to when this was indicted. It occurred on October 17th. The charges are strangulation, as I outlined, domestic violence and disorderly conduct. That case has since been bound over. He is out on bond in that case, which is $10,000 cash surety or 10%. He had a new arrest while out on bond. Additionally, it was brought to my attention that he was tested for substances when he was arrested, and the test showed that he was positive and confirmed him to be positive for alcohol at the time of the incident and for THC.
At the time of the jog incident.
Correct. He took another test about 5 days later. There was not alcohol, and the THC levels were dropping.
Where was that test?
That was also in Charter Municipal Court. The incident itself also occurred because the defendant went with the victim to a bar, and the victim had reported that he continued to drink throughout the incident and what occurred. So state's position is to revoke bond because this case is a case that deals with substances, and while out on bond and having the condition to not consume any substances or alcohol, he did so and then harmed someone, and more charges arose from that. I did briefly discuss this with defense counsel, and I will just state that if bond is not revoked and if there's some monetary amount that the court feels is appropriate, I'd ask that scram also be put in place for this defendant. Thank you.
Thank you. Ms. Thomas, you want to be heard on bond?
Yes, thank you, Your Honor. I've had a few conversations with Mr. Seymour today regarding his bond. Your Honor, if the court would choose not to revoke his bond, he would be more than willing to accept a cash surety bond. He'd be more than willing to wear scram. Your Honor, he would even be willing to come in and do random drug screening.
I want to know why I shouldn't revoke his bond. There's a condition of bond. He failed to comply with it. What's the purpose of having conditions if we're just going to ignore them?
I understand, Your Honor. He indicated to me the victim or the alleged victim in the case through Geauga County he is no longer in contact with. It's not an excuse, Your Honor. He said it was a very bad relationship, but they are no longer in contact. He is wearing a GPS monitor through Geauga County. He is now living with his dad and his stepmom. He's in a much better environment. He is working full-time, Your Honor. He does pay $900 a month in child support. He really does want to get these cases resolved, Your Honor. He wants to do what he can to be a productive member of society. That's why he is so willing to wear the scram bracelet and paid for that, willing to do random screens through probation. Like I said, Your Honor, it's no excuse. He just indicated it was a very bad relationship he was in, but no longer in that relationship and now is living in a new environment, Your Honor. I do have a good address and phone number for him as well. He would be living in Roaming Shores with his dad, who is here today, and with his stepmom. Thank you.
Now, Mr. Seymour, conditions of bond aren't suggestions. They're court orders that you have to comply with. So I'm having a hard time why we should let you continue being on bond when you knowingly violate the conditions of bond. You knew that one of the conditions to your freedom, and you chose to disregard it, drink, do whatever else happened. And now you want to come here and say, I don't know what you're trying to say, actually. I don't know why we shouldn't be honoring that.
All I can say is it was very mentally.
Well, you shouldn't, and you shouldn't comment on anything about that incident, actually. Pending charges there, and you shouldn't make any comments about that.
Yes, Your Honor.
And I'm saying that for your own interest, not trying to shut you up or anything. You just shouldn't comment on that other case and that day. That's what I'm going to do. I'm going to reset bond at defendant's owner cognizance with the condition that he use scram. But I'm also going to send you over, so you're going to have to go back, you're going to have to go to the jail to get that all hooked up. But I want you tested today by the probation department. If those tests should come back positive, then I'm going to revoke your bond immediately. So bond will be set at owner cognizance with SCRAM monitoring. Anything else for the record at this time?
No, thank you.
Ms. Tomczak?
No, Your Honor, thank you.
Thank you.
All rise.